Hello, everybody. It's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to give you a brief overview of the 13th Amendment to the United States Constitution. The purpose of this video is to give you a basic understanding of both the background and operative purposes of that landmark addition to the Constitution. Simply put, the 13th Amendment forever abolished slavery and involuntary servitude in the United States of America, except as punishment for a crime wherein the party shall have been duly convicted. It was the first of the three Reconstruction Amendments, aka the Civil War Amendments, the latter two being the 14th and 15th Amendments to the Constitution, respectively. So let's touch on first the background of the 13th Amendment, which begins with the Emancipation Proclamation issued by President Abraham Lincoln on January 1st, 1863. While that landmark proclamation was certainly noble in its intentions, it did not in any way settle the status of enslaved African Americans or the slavery question in general in America. For sure, it would take almost 2 years for the proclamation itself to even reach every part of the Confederacy, aka why we celebrate Juneteenth every year. All right? As such, the Republican Party made it a point to include in their presidential platform in 1864 that they would support an amendment to the United States Constitution which would forever abolish slavery in this nation. They were very serious in getting such an amendment crafted and submitted to the states as soon as possible. So thus, pursuant to the requirements in Article 5 of the Constitution, Congress began crafting such an amendment, and several proposals were drawn up immediately. The very first, done by Representative James Ashley of Ohio, was submitted in December of 1863, followed by one from Representative James Wilson of Iowa. In January of 1864, Senator John Henderson of Missouri would also submit a joint resolution for a constitutional amendment abolishing slavery. Senator Charles Sumner of Massachusetts and Representative Thaddeus Stevens of Pennsylvania, who were both radical Republicans, sought a broad revolutionary version of the amendment. Sumner's proposal, submitted on February the 8th, 1864, reads as follows: "All persons are equal before the law, so that no person can hold another as a slave. And the Congress shall have power to make all laws necessary and proper to carry this declaration into effect everywhere in the United States." I like that version. That's what should have been adopted. But Sumner's language was obviously too radical for many, and instead the Lyman-Trumbull-led United States Senate Judiciary Committee ultimately decided to put forward a bill on the 10th of February, 1864, that combined the language from the bills previously submitted by Ashley, Wilson, and Henderson. It also borrowed heavily from the text used to prohibit slavery in the Northwest Ordinance of 1787, which read that there shall be neither slavery nor involuntary servitude otherwise than in the punishment of crimes whereof the party shall have been duly convicted. So the bill submitted also removed language from Henderson's bill, although retaining virtually all of the rest, which would have ultimately required that the amendment's passage be accomplished by a simple majority of each House of Congress and by only 2/3 of the states, as opposed to the Constitution's required 2/3 majority in each House of Congress and 3/4 of the states. See a problem with that? Yeah, I do too. Although certainly benevolent for this, that certainly would have been used as a very bad precedent for some not so great amendments which would follow later on in the 19th and 20th centuries, respectively. All right, so ultimately the final text of the 13th Amendment would read as follows. Section 1, "Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction." Section 2 reads as follows. "Congress shall have power to enforce this article by appropriate legislation." So who wants to tell me what's unique about Section 2 compared to virtually every other amendment? You got it. It has a specific grant of enforcement power to Congress. No other amendment before that contained such a grant. All right? So, On submission, the proposed 13th Amendment passed the U.S. Senate in roughly 2 months. On April 8, 1864, by a supermajority of 38-6, 2 Democrats, both of Oregon senators, would cross party lines to approve the proposed 13th Amendment to the Constitution. That's April 8, 1864, by a 38-6 vote. In the House of Representatives, however, the struggle was much more fierce. And in their initial vote on June 15, 1864, the amendment failed with 93 yeas and 65 nays, 13 yeas short of the minimum needed to pass. So for the rest of 1864 and early 1865, a whole lot of politicking, promising, bribing, and corruption out the wazoo took place to get enough members of the House of Representatives to support the proposed 13th Amendment. All right, this is certainly dramatized very heavily in the 2012 movie entitled Lincoln. If you've never seen it, watch it, and you'll get a very good gist of just how difficult it was to get those recalcitrant members of the House of Representatives to vote in favor of the 13th Amendment. And some of these representatives were Republicans. Folks, it wasn't just about getting, these difficult Democrats to cross party lines to vote it. They also had to struggle to get Republicans to vote for it in certain circumstances too. Not everybody was on board with the 13th Amendment. Not even the full Republican Party, which had crafted it. Okay, so when President Lincoln was reelected in November of 1864, support for the amendment continued to grow, and the president threw his full support behind it, all right? Definitely pressuring these recalcitrant members of the House to vote for it. When the next vote took place on the 31st of January, 1865, it was rough, but the amendment passed by a vote of 119 to 56. And in a very unusual step, Congress sent the measure to President Lincoln for his signature, though such a thing is not required by the Constitution. All right, the president has no formal role in the amendment process, if you weren't aware of that. All right. So, after being submitted to the states for ratification, very next day, on the 1st of February, 1865, it had to be ratified by at least 27 of the 36 states in the Union at the time. Remember, an amendment requires 3/4 of the states to approve. And Congress required the legislatures of the legislatures to approve the amendment. The Constitution requires that either the legislatures or conventions in 3/4 of the states approved a proposed amendment. And in this case, they required that the legislatures approve the amendment in those states. So, once the amendment was submitted to the states, the legislatures would soon comply. And, accordingly, the first state to ratify was Illinois in February of 1865. And the 27th and decisive state to ratify was Georgia on December the 6th, 1865. And on December the 18th, 1865, Secretary of State William Henry Seward officially proclaimed it to be a part of the Constitution, 8 months after the assassination of President Abraham Lincoln. When the amendment was ratified, all right, aside from the virtually complete emancipation which had taken place in the South by this time, all remaining slaves that were still held in bondage in the following states of Kentucky, New Jersey, and Delaware were immediately emancipated, ladies and gentlemen. And the 13th Amendment's work for that purpose essentially was complete. Having been ratified by the necessary 27 of 36 states, 3/4 of the states submitting, it became a part of the Constitution. Slavery was abolished in America. Now, to the tail end of that amendment, involuntary servitude, except as punishment for a crime, wherein the party shall have been duly convicted. The amendment also allows for what is known as penal labor, folks. And that is simply forced labor while you are a prisoner, all right, having been convicted and serving time in prison. All right, failure to comply with that could result in further punishment. Certain states specifically prohibit that, all right, other states specifically allow it. But that is the whole gist of the 13th Amendment. This allows you to now go and do your homework on anything else you may want to know. Thanks for listening. Any questions, leave them down below. Professor Shelton